Good evening friends, you are most welcome to Civil Affairs. Today we are going to discuss Vision IS PT 365 updated classroom study material from January 2024 to March 2024. Our topic is Epidemic Disease Act EDA 1897. Let us begin the topic. Why in the news? Recently the 22nd Law Commission of India LCI submitted a report titled A Comprehensive Review of the Epidemic Disease Act 1897 to the Government of India. More about the news, the LCI Law Commission of India suo motu undertook the examination of Epidemic Disease Act 1897 ED 1897 and International Health Regulation IHR 2005. LCI Law Commission of India highlighted key issues in EDA Epidemic Disease Act 1897. Law grants excessive government power risking abuse. Law grants excessive government power and risking abuse. Does not define an epidemic or an infectious disease and does not differentiate between the outbreak, epidemic, and pandemic. The Act lacks specific guidelines for effective disease surveillance, quarantine process, availability of drugs and vaccine, etc. The Act does not provide statutory power to local governments to regulate epidemic diseases. It recommended to either amend the existing law or bring a new comprehensive legislation to address existing gaps. Key highlights of the EDA 1897 Genesis. The British government introduced EDA Epidemic Disease Act to tackle the epidemic of bubonic plague in the erstwhile Bombay Presidency in 1896 when Lord Elgin II was the viceroy from 1894 to 1899. Powers to government grants extensive powers to the government to regulate, prevent, and control the dangerous epidemic diseases, allows the central government to inspect ships and vessels departing from or arriving at ports within its jurisdiction. 2020 Amendment. The Epidemic Disease Amendment Act 2020 was enacted to stop the violence faced by healthcare workers during the COVID-19 pandemic. Under 2020 Amendment, violence against a healthcare service personnel or damage or loss to any property shall be punished with imprisonment for a term of 3 to 5 years and with fine of 50,000 rupees to 2 lakh rupees. International Health Regulation IHR, it was adopted by the World Health Assembly in 1969 and revised in 2005. It is an overreaching legal framework for public health events and emergencies that have potential to cross borders. It is legally binding on 196 countries including the 194 WHO member states, create rights and obligations for countries including the requirement to report public health events, outline the criteria to determine whether or not a particular event constitutes a public health emergency of international concern. Our next topic is temple regulation in India. Why in the news? Karnataka Legislative Assembly passed the Karnataka Hindu Religious Institution and Charitable Endowment Amendment Bill 2024 to regulate temples in the state. Legal and institutional framework to regulate temples. Article 21 Article 25 Clause 1 Article 25 Clause 1 equally entitles all persons to freedom of conscience and rights to freely profess, practice and propagate religion subject to public order, morality and health. Article 25 Clause 2 enables the state to enact laws to regulate or restrict any economic, financial, political or other secular activity associated with the religious practice. State can also make laws for social welfare and reform or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Article 26 provides for the freedom to manage the religious affairs of the citizens and is subject to public order, morality and health. Entry 28 of List 3 concurrent list of Schedule 7 empowers both union and state legislatures to make law on charities and charitable institutes, charitable and religious endowments, and religious institutions. Hindu religious and charitable endowments (HR and CE). Several states across the country have enacted legislative and regulatory framework to regulate these institutions through the powers accorded by the Constitution. Hindu Religious Endowment Commission 1960. The commission declared the government control over temples was essential to prevent maladministration. Temple regulation in the colonial period. Religious Endowment Act of 1863 was enacted to establish local committees to oversee the temples. Madras Hindu Religious Endowment Act of 1925 provided oversight of the management of temples through a board of commissioners with enormous powers. Our next topic is the Cinematograph Certification Rules 2024. Why in the news? Under the Cinematograph Amendment Act 2023, the Union Ministry of Information and Broadcasting has notified the Cinematograph Certification Rule 2024, replacing the Cinematograph Certification Rules 1983. Key aspect of the Cinematograph Certification Rules 2024. Terms of office. A member of the board shall hold office during the pleasure of the central government. Representation of women. It stipulates that one third of the members in the board shall be women, and preferably half shall be women. Constitution of advisory panel. The central government shall constitute an advisory panel at each of the regional offices of the board. Constitution of advisory panels. The central government shall constitute an advisory panel at each of the regional offices of the board. Improved efficiency by reducing timelines for the processing of film certification and adopting complete digital process for eliminating all transactional time. Further classification of UA. Subdivision of the existing UA unrestricted with caution category into three more age-based categories. See infographics. Categories of film certification. Category U, certified audience, universal and without restriction. UA category into three age-based categories: 7 years UA 7 plus, 13 years UA 13 plus, 16 years UA 16 plus instead of 12 years. Without restriction but subject to guidance of parents and guardians. A certificate category only for adults. S certificate only to members of any profession or class of persons. It will ensure young viewers are exposed to age appropriate content. It would be voluntary. Provision for priority screening for expediting expediting the screening of film for certification in case of any urgency felt by filmmakers due to their prior commitments to release the film. Change of category of film for television. Recertification of the edited film for television broadcast, as only unrestricted public exhibition category films can be shown on television. Perpetual validity of certificates. Restriction of 10 years on the validity of the certificates has been removed and will be given perpetual validity. Related news. The Ministry of Information and Broadcasting MIB recently introduced guidelines aimed at enhancing accessibility standards for persons with hearing and visual impairments in the public exhibition of features films in cinema theaters. The initiative aligns with the Rights of Persons with Disabilities Act 2016, RPWD Act, which mandates government action to promote universal access and inclusion in information and communication, including access to films. Other important news: prevention of damage to public property. Recently, 22nd Law Commission submitted 284th report titled Prevention of Damage to Public Property. Constitutional and legal provisions of for prevention of damage to public property. Fundamental rights under Article 19, Clause 1, Subclause A, right to freedom of speech and expression, and Article 1, 19(1), Subclause B, to assemble peacefully and without arms, implicitly contains the right to protest. However, demonstration which creates nuisance and disturbance are not covered under it. Fundamental duty is Article 51A, duty of every citizen to safeguard public property and to abjure violence. Prevention of damage to public property, PDPP Act 1984 contains provisions dealing with mischiefs resulting in damage of property, public property. Section 425 to 440 of the Indian Penal Code (IPC) deal with it. Public Examination Prevention of Unfair Means Act 2024. Recently, Parliament enacted the Public Examination Prevention of Unfair Means Act 2024. Key features of the Act: coverage examination held by the Union Public Service Commission (UPSC), the Staff Selection Commission, Railways, National Testing Agency, NTA, etc. Offences will be recognizable, non-bailable, and non-compoundable. Involved parties cannot compromise. Provisions for punishment: minimum 3 to 5 years of imprisonment and with a fine up to 10 lakh rupees. Organized crime groups will face 5 to 10 years of imprisonment and a minimum fine of 1 crore rupee. Union Ministry of Personnel, Public Grievances and Pension has also decided to set up a high-level National Technical Committee on public examinations. Let's repeat the prevention of damage to public property. Recently, 22nd Law Commission submitted 284th report titled Prevention of Damage to Public Property, Constitutional and Legal Provisions for Prevention of Damage to Public Property, Fundamental Rights under Article 19(1)(a), Rights to Freedom of Speech and Expression, and Article 19(1)(b), to assemble peacefully and peaceably and without arms, implicitly contains the right to protest. However, demonstration which creates nuisance and disturbances are not covered under it. Fundamental duties: Article 15(1)(a), Article 51(a), duty of every citizen to safeguard public property and to abjure violence. Prevention of damage to public property, PDPP Act 1984 contains provision dealing with mischiefs resulting in damage of public property. Section 425 to 440 of the Indian Penal Code (IPC) deals with it. Thank you very much.